And I co-direct the program in public law here at Duke Law School. I want to welcome you to today's event, aptly and cutely entitled Citizens Disunited, a discussion of the recent campaign finance decision. We have with us today two very prominent commentators on the subject of campaign finance legislation. Jean Nichol is professor of law and director of the Center on Poverty, Work, and Opportunity at the University of North Carolina. He teaches courses in constitutional law, federal courts, civil rights, and election law. From 2005 to 2008, Professor Nichol was the 26th president of the College of William and Mary in Williamsburg, Virginia. He was also dean of the law school at UNC from 1999 to 2005. Mike Munger, to my immediate left, is professor and chair of the Department of Political Science here at Duke. He's also a professor in the Department of Economics and Public Policy. His research interests include the study of ideology, legislative institutions, elections, and public policy, especially campaign finance. In 2008, Professor Munger gave the keynote speech at the Libertarian National Convention in Denver, Colorado. Later that year, he was nominated and ran in the general election for the office of governor of North Carolina. It turns out he didn't win, but he is working on a book on the experience. And the book is tentatively entitled, "You Aren't Going to Win, Are You?" Okay, we are honored that Professors Nichol and Munger are taking the time to be with us today. We are privileged to have them here. I thought I would begin by providing some pertinent legal and factual background on the Citizens United case, and then turn over to Professors Nichol and Munger, who will speak for approximately 10 to 15 minutes. And depending on the time, I may offer a few big picture thoughts of my own, and then I want to open it up to you folks for your questions and comments in response to what you hear. So let me start with federal campaign finance law. As it was amended in 2002 in the Bipartisan Campaign Reform Act, also called BICRA, federal law prohibits corporations and unions from using their general treasury funds to make independent expenditures for speech that is, quote unquote, an electioneering communication, or for speech that expressly advocates the election or defeat of a particular candidate. And the statutes define electioneering communication as, quote, any broadcast, cable, or satellite communication that refers to a clearly identified candidate for federal office and is made within 30 days of a primary election, end quote. Corporations and unions may establish a political action committee, a PAC, right, for purposes of engaging in express advocacy or for purposes of making electioneering communications. In 2003, in the McConnell case, McConnell against Federal Election Commission, the court, fracturing 5-4, upheld the federal limits on electioneering communications and rejected a facial challenge to BICRA. The court, in doing so, relied on its 1990 rationale in Austin against Michigan Chamber of Commerce. And what the majority in Austin reasoned was that government has a compelling interest in, quote, limiting the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form and that have little or no correlation to the public support for the corporation's political ideas, end quote. Right, so that is the language from Austin in 1990 that the court in McConnell in 2003 invokes in order to uphold the federal ban on electioneering communications. In Austin, Justices Scalia, Kennedy, and O'Connor dissent. Justices Scalia and Kennedy continue to dissent in McConnell, right, but by this time, 2003, Justice O'Connor is now decisive in the majority, indicating that her views had changed over time. The Citizens United case arose after Justice Alito replaced Justice O'Connor. In January of 2008, the appellants, Citizens United, a nonprofit corporation, released a documentary, right? You may have heard, Hillary, the movie, that was critical of then-Senator Hillary Clinton, who, of course, was a candidate for the Democratic Party's nomination for president. And Citizens United anticipated that it would make the movie Hillary available on cable TV through satellite or through video on demand within 30 days of primary elections, and because they anticipated that, they produced TV ads advertising the movie that would run on broadcasting cable TV. Citizens United understood federal campaign finance law and was very concerned about possible civil and criminal penalties for violating the prohibition on electioneering communications, and sued in federal court seeking declaratory and injunctive relief. And specifically, Citizens United argued first that the law is unconstitutional as applied to Hillary the movie, and second, that the disclaimer, disclosure, and reporting requirements in the law were unconstitutional as applied to both the movie, the documentary, as well as the advertisements. Now, the procedural history of this case is worth noting. It's initially argued on March 24th of last term, and instead of deciding the case by the end of last June, which is the court's usual practice, instead, on June 29th, the court issued a miscellaneous order restoring the case to the calendar for re-argument. And the re-argument was to take place on September 9th, earlier this year, and the court directed the parties to file supplemental briefs addressing whether the court should overrule either Austin, or the relevant part of McConnell, concerning the constitutionality of federal regulation of the electioneering communications. Well, the decision is handed down on January 21st, 2010. The court divides 5-4, but now the opposite way that it fractured in McConnell. The court, on the one hand, upheld the disclaimer and disclosure requirements, as applied to the ads and as applied to Hillary, the documentary, but held unconstitutional, facially invalidated the federal prohibition on electioneering communications, the ban on allowing corporations and labor unions to use the general treasury funds, to pay for electioneering communications. And in reaching this result, the court both overruled Austin as well as the relevant part of McConnell, reasoning that Congress may not prohibit political speech based on the corporate identity of the speaker. The decision has generated great controversy, President Obama explicitly criticized it in his State of the Union address. Both the House and the Senate have held hearings on the subject, and presently Senator Charles Schumer and Congressman Chris Van Hollen have introduced campaign finance legislation in response to the decision. Questions about it abound. For example, who won? Is this a victory for the First Amendment, or is this merely a victory for corporations with huge financial resources? What are the actual consequences of the decision likely to be? Does anyone really know? Are the various legislative responses to the decision that are currently under consideration in Congress constitutional? Are they sensible as a matter of policy? What, if anything, does this case, the re-argument, the explicit overrulings of precedent, the apparently ideological division of the justices suggest about what kind of court the Roberts Court is shaping up to be? For answers to these and other pertinent questions, I turn now to Professor Nichols and Munger. Professor Nichol.
Thank you, Neil. It's delightful to be here. It's been my pleasure to do various lectures and conferences and classes at Duke over the last 15 years. It was always a little less emotionally confusing back 15 years or so before I came to Carolina. Back when it was still culturally permissible for me to like Duke, which I did, I would confess, but no worries, I'm no longer in that odd category. I do find it easier to commune together this year since they apparently decided at some point that there would be no ACC basketball season in 2010. Thank God. I actually have strong affection for the Duke Law School, if not the rest of the place. Too many friends here for too long, I suppose. I will say, though, that I've discovered some years back that you have to be careful coming over here. The first time I did was, I think, in the early 1990s to give one of your many generously endowed lectures. And you know the drill. I gave a talk, they dragooned a bunch of students into coming. 2 or 3 professors gave comments, and 1 lawyer from the Solicitor General's office appeared to make comments as well. It was all published in the Law Review and quickly forgotten, even by me, especially by me. That is until about 5 years ago. It turns out, unbeknownst to me, that the lawyer from the Solicitor General's office who made comments was named John Roberts. And his piece in the Duke Law Journal was apparently his only published essay to be examined during his hearings. So all we really knew with certitude when John Roberts was elevated to the highest judicial position in the world was that he thought my jurisdictional theories were a crock of shit. I explained to the national press that this put him solidly within the mainstream of American legal thought. I'm going to try and be brief to start us off. I'll begin just by saying there are a few things about the Citizens United case that I find myself cranky about. The first, I'm confident we can all agree on, and if you don't agree on it now, you likely will later, and then that'll probably be the end of our agreements, and that's as it should be. But first, initially, on behalf of law students and law professors, neither of whom are apt to be working by the hour, I am sick of, 175, 200, 250-page opinions by the United States Supreme Court. I like Justice Stevens, but an 88-page dissent is probably more than is called for.
He apologized for it.
I guess I could say that the only thing I liked about Justice Thomas' opinion was its length, 6 pages, which is much more my style. But 200 is rank cruelty to any of us. And speaking of cruelty, if you look closely, which hopefully none of you have done, but if you look closely at the majority opinion, to bolster his, some would think, shaky claims, Justice Kennedy wrote, and I quote, Bellotti, which is one of the cases he needs to attack, Bellotti's dictum is supported only by a student comment in a law review which misinterpreted Buckley against Vallejo. Then he cites the unfortunate student comment from the University of Pennsylvania Law Review. Imagine your own plight being singled out explicitly in a United States Supreme Court opinion explaining how lousy your student work product is. Cruel and unusual. Second, on the cranky front, God save us from these passive, modest jurists, those who preach to be disciples of judicial restraint, the Chief Justice who, quote, just calls the balls and strikes, deciding these thorny disputes with the smallest possible compass. Here, where as Neil indicated at least a bit, the court's restrainers, modest pacifists, overruled 2 cases directly on point, one from 1990, one from 2003, when they clearly didn't have to reach this newly created right of corporate electioneering at all. When it looks like the parties didn't seek it, the court brought it up itself and scheduled re-argument on the point, actually sort of filing their own lawsuit, unsettling either 30 years of law or 103 years of law, depending on how you choose to look at it, beginning the opinion disingenuously with the statement, "We are asked here to reconsider Austin." I suppose they didn't want to say that we asked ourselves to reconsider Austin. I think Justice Scalia got it right 2 terms ago when he said Chief Justice Roberts, quote, "faux judicial restraint is nothing but judicial obfuscation." Third, speaking of Justice Scalia, God save us from the occasional originalist, dreaming that Citizens United is driven by the framers' vision of the First Amendment, Madison, Wilson turning in their graves, Jefferson, though perhaps not a framer, surely a founder, spinning in his grave. It is at least true that no vision of the original meaning of the First Amendment could support this decision unless it is rooted in such a lofty level of generalization that originalism loses all of its cabining possibility, which is the basis for its strength as a theory. We obviously need not only a theory of originalism, but a theory which explains, as in the affirmative action cases and the Voting Rights Act cases and the 10th Amendment cases, and now in the corporate speech cases, when you're free to ignore the theory that you otherwise espouse. Fourth, and more important, these objections so far are tiny ones, mere matters of etiquette. I don't think anyone who reads actually thinks Chief Justice Roberts is an incrementalist referee or that Justice Scalia is an originalist. Campaign finance law is lousy. The Congress, and especially the Supreme Court, by constantly leaving only half of various regulatory programs standing, have made it inconsistent, incomprehensible, and infuriating. I don't deny that. It is chock full of distinctions without a difference and loopholes that are loopy. Still, Citizens United marched up a hill to declare enthusiastically, unnecessarily, and probably unalterably that corporations are free to spend unlimited amounts of money from their astonishingly ample treasuries in federal, state, and local elections to support or defeat candidates. There are many things that could be said about that, but the one I can't get over is this. Now, let's say that Congressman Brad Miller is trying to decide whether to support a bill taxing these handout-driven, obscene bonuses given by various banks. After Citizens United, Bank of America's lobbyist can say, I'd guess directly or indirectly, privately or publicly, if you vote our way, we're prepared to spend a couple million in ads on your behalf next year. If you're against us, we're going to spend a couple million to take you out. And that's true across the land, at all levels of government, and in all branches of government, including judicial elections. It is fascinating to compare Citizens United with Caperton. 2 weeks ago, we celebrated the 50th anniversary of the sit-in movement triggered in Greensboro. After it had been rolling for about 3 weeks, Dr. King came to Carolina to support the sit-ins. He said that these young men had shown that the brutal practices of segregation and the high promises of the Constitution could not be squared. And what I liked, and quote, that all the theorists and all the logicians in the world can't make them lie down together. This ruling is not nearly as important as integration. I'm not saying that. But the notion that if you don't vote my way, I'm dropping a couple million to take you out, which is now, I suppose, lionized, beautified, made sacred as part of our political discourse, that can't be made to lie down with egalitarian democracy. It means that all campaign finance limitation is made silly. It seems to bookend, in my view, the court's decision in Bush against Gore over a decade ago, putting an inappropriate thumb on the operation of the democratic process. It's not surprising, I would guess, that President Obama would say, quote, the Supreme Court has overturned a century of law and given a green light to a new stampede of special interest money in our politics. Or that Michael Steele, on the other hand, would declare that it massively strengthens our democracy. While Mitch McConnell would say, I assume cynically with upturned lip, for too long in this country, some have been denied full participation in the political process. These new discrete and insular corporate minorities. It might be worth paying more attention to Senator Chuck Hagel, moderate, Republican, long understood to be a straight shooter, who obviously understands the system, when he said that lobbyists and corporate operators will now run wild. This is an astonishing blow to good government that will so debase our system that we may not be able to govern ourselves. I don't deny, as I said beginning, that our prior patchwork of campaign finance law, because of its complexity, and principally because the Supreme Court has made mincemeat of so much of it in the last 3 decades, is infuriating and inadequate and readily subject to derision, based on distinctions between expenditures and contributions, between PACs and individuals, between independent and coordinated efforts, between wealthy individuals and wealthy corporations that are porous and largely indefensible. But Citizens United won't fix that. It'll just swamp it in a corporate tide. We'll still have to draw, I assume, incomprehensible lines. For example, now, a lot of state legislatures, and maybe the federal one, are not going to be happy with this decision. So they'll pass corporate governance laws to try and get at the problem. Shareholders will have to approve political expenditures, maybe by a majority, maybe by a supermajority. And the Supreme Court, I'm guessing, the five, they won't like that. They'll rebel at that. So we're going to have to constitutionalize various rules of corporate organization and constitutionalize them out of whole cloth. And I assume that there will be at least modest consternation when regular Americans learn that now local corporate subsidiaries of the Chinese government or the Saudi Arabian government have so much more clout in their elections than local citizens do. So we'll get laws against this, and then we'll have constitutional constraints against those laws. Foreign ownership, how much foreign ownership, how much foreign stock ownership, it'll be endless and complex and indefensible without good reason. And if you were thinking that this would rid us of silly distinctions, the entire theory of Citizens United is premised on an assumption that no one, literally no one involved in politics, believes to be true. That is, quote, the absence of prearrangement and coordination of expenditures, that is, the formal independence from a campaign. This defeats concerns for corruption or appearance of corruption and eliminates the risks of improper influence or on commitments by candidates. No one thinks in politics that is a line that holds. So for me, I think the court has damaged the democracy in Citizens United and likely damaged itself as well.
Thank you. Thank you very much. Professor Munger.
Well, hey. I think Neil made a mistake in introducing me because he said that we were going to say pertinent things, and that's not true. I intend to be impertinent. Political scientists and people who study public choice theory study the architecture of government. Lawyers are the building inspectors of government who come in to check to see whether or not the building code is being followed. Their expertise does not extend to decide whether the building code is in fact a good one or not. They have to rely on people that understand architecture. So, if I may, let me begin by reading the First Amendment. Most constitutional laws classes don't actually cover the First Amendment, so I want to remind you of it. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, I'm going to raise my voice now, or of the right of the people peaceably to assemble. Things we often don't hear in this debate are about the importance of groups. This isn't about a question of freedom of speech. This is about the right of groups of people to get together so as to overcome the problems of collective action and transactions cost that enfeeble the individual in a democracy. If you read Tocqueville's Democracy in America, published in 1831, he said that the thing that he thought was enfeebling the citizenry of France was the fact that they felt that having once voted, their social obligations had been exhausted, that he didn't see the rich interwoven fabric of groups that he saw in the United States. It is the fact that politics requires groups that I think many critics of this decision are missing. This is not a question of freedom of speech. This is the question of the right of assembly into groups. And how are we to decide, and under what circumstances, are some groups to be allowed to speak and other groups to be denied that ability, the capacity to speak. No, you do not get to speak. You do not get to act. Now, one standard we might use is self-interest. I submit that's a difficult standard to use. No one can speak in their own self-interest. Well, presumably, no. In fact, self-interest is something we always argue about. So the fact that corporations are self-interested, that doesn't seem like a very good standard. Another possibility that we might use is corporations are too powerful. Well, there's a lot of research in political science, that is the study of architecture, not the study of building codes, that would say that large corporations actually need to participate very little in the political process. Groups that will be excluded by the kind of campaign finance law that we have will be those in the middle and those smaller ones. And in fact, Citizens United had just put together a movie. They had taken some contributions, but they had put together a movie. And they were told that, maybe Michael Moore would be told also, if your movie contains any political content of an electioneering sort, not express advocacy, but of an electioneering sort, in the sense that you say Hillary Clinton is running for office, the election is November 4th, that would qualify it as being regulated under the law that existed until this decision. Now, I have to admit, I actually agree with Gene on two things. Both of these may surprise him. This decision is overwrought to the point nearly of being hysterical. When I first heard the outcome, I thought, oh, good. And when I first read it, I thought, what are these people doing? It extends so far beyond what was necessary. Second, I'm a UNC fan also. So I do want to concede both of those things. Nonetheless, let us look for a moment, taken as written, his criticisms of the decision. Let's look at some of the things it was trying to remedy. I worked for the Institute for Justice on 3 cases under the extensions of McCain-Feingold and its definition of electioneering. One of those cases in the state of Florida, there was a law about disclosure. Laws about disclosure have a chilling effect disproportionately on groups that are small. Large corporations already have accountants. Any sort of restriction that says you have to have a treasurer and you have to have a certain number of reports actually excludes not the large groups, which, as I've already said, have a disproportionate influence without participating in contributions. So, University of Florida, college Democrats. We're having in an outside speaker, Congressman Smith. Congressman Smith was going to speak on September 20th in, let's say, room 101. College Democrats put up ads. These ads, under the Florida statute, because they could reasonably be anticipated to reach at least 1,000 people, were regulated political speech. There was no express advocacy. All they did was contain the information there's an election November 4th, and Congressman Smith is going to speak at a certain date, time, and place. College Democrats at the University of Florida were prosecuted under the Florida statute for having not formed a political action committee. You only get to speak if you say Simon says. Groups don't get to speak on their own behalf under that law. Now, that law was also overturned, but that harassment, I think you have to understand what actually is the role of the state. That harassment is largely because the state is run by incumbents, all of whom find it most inconvenient to have to face the voters in even-numbered years. It's very inconvenient to have an opponent. It's very inconvenient to find someone who has enough money to be able to run ads. John McCain, over and over, during the argument for McCain-Feingold, would say he really resented having those ads run against him. Well, I bet he did. But that's part of what makes a competitive democratic system possible. There has to be countervailing power. Let me finish with some conclusions, and then I'll talk for a minute to try to justify them. In my Senate testimony, when I testified before the Rules and Administration Committee, in 2000 against the passage of McCain-Feingold, my written testimony was about the importance of parties and the importance of a political theorist named E.E. Schatznyder. E.E. Schatznyder said that in the absence of strong party government and a competitive democracy, what you always get is interest groups. Now, it's true that progressive reformers have in mind a non-existent ideal. Progressives are the political equivalent of Protestants. They want a priesthood of all believers, and they want no intermediary institutions. What they would like to do is to have individuals commune directly with the godlike figures in the Senate. It can't happen. The only thing that you have is organized interest groups. The only mechanism by which people can have an influence in a democracy is organized interest groups. Schatznyder pointed out that the main thing that top groups and politicians wanted to do was reduce the scope of conflict. Having outsiders be able to run ads expands the scope of conflict. It means that you can no longer be certain that yours are the only voices that are going to be heard. And in fact, there may be a debate, whereas otherwise there might not be one at all. Madison, in Federalist Number 10, basically said, politics abhors a vacuum. He's talking about faction. Organized, self-interested interest groups like corporations. And he's considering in Federalist 10 the question of whether we should get rid of these factions. It could never be more truly said than of the first remedy, it's worse than the disease. Liberty is to faction what air is to fire, an element without which it instantly expires. But it could not be less folly to abolish liberty, which is essential to political life, because it nourishes faction, than it would be to wish the annihilation of air, which is essential to animal life, because it imparts to fire its destructive agency. The answer to speech you disagree with is more speech. This will expand the scope of conflict. Large corporations already dominate. The progressive mistake is to think that by getting rid of intermediary institutions, we increase the power of the individual. That's wrong, as E.E. Schatznyder and a number of other architects, as opposed to building code inspectors, have argued. Well, the rule then is simple. Any rule that weakens the right to assemble strengthens organized interest groups. It seems paradoxical, but the political science literature speaks basically with one voice on this question across ideological lines. The last thing I wanted to say was, let me read just a little bit from the first time that there was oral argument in the Citizens United case, because it was made to seem, and perhaps not quite inappropriately, that the judges decided to bring a lawsuit themselves. Asking for a re-argument is pretty odd. Why would they do that? Well, here's some of the testimony that elicited that response. The Deputy Solicitor General was Malcolm Stewart, and his job was to argue the case for the Federal Election Commission. So he's trying to persuade the court that they should ban 90-minute attack ads. So Alito, Justice Alito, asked whether the government, if it can regulate documentaries, might also regulate a book containing express advocacy. And Stewart said, yes, it could. You could not publish a book within 60 days of an election if you intend to advertise it and say, buy my book. That's pretty incredible, splutters Alito. If a book was published, a campaign biography, because remember, it doesn't have to be an attack, it could be advocacy. So I published my campaign biography and say, I am one fine fellow. Now clearly that would be a lie, but fraud is a different problem. I say, I'm a fine guy, vote for me, in one sentence, somewhere in a 500-page book. Solicitor General agreed that was banned under the law. You can't publish a book. Well, except not within 60 days of an election. So you could prohibit the use of corporate treasury funds. How are you going to publish a book? Are you going to self-publish it? All of the books that you've ever seen, who published them? Corporations. Maybe it's a nonprofit corporation, maybe it's a for-profit corporation. If that's regulated speech, then there is no corner of what we have available to us to think about that's not regulated. So Anthony Kennedy gets even paler than his usual extremely white self. What about Kindle? That's from a satellite. So the existing statute would prohibit you from reading on Kindle if it's electioneering, not just express advocacy, but if it's electioneering. Stewart said, well, no, it's not banned, but the corporation couldn't use any of its corporate treasury to buy an ad saying, please buy this on Kindle. So the Chief Justice said, again, even in a 500-page book with one sentence, and Stewart cheerfully agreed. They asked him about a sign. What about people holding up signs in Lafayette Park? Yes. Yes, that would also be banned if it was a nonprofit organization or corporation. So, again, in Florida, a group of condominium owners who they were the condominium, the organization that runs the condominiums, disagreed with a ballot initiative. They bought some posters and some yard signs. They failed to organize. They failed to get a treasurer. They failed to disclose. They were brought up on charges by the state of Florida. So this decision goes much farther than it has to. And the distinction to me between nonprofits and for-profits, I don't know why it allied so much. But what I want to claim is the law that this decision attacks was worse than confusing. It was unconstitutional. Thank you.
Thank you. Thank you very much, Professor Munger. Well, I thought we have until 1:15, so maybe I'll just speak for very few minutes and offer some more general big picture thoughts about what, if anything, this decision suggests about the Roberts Court. And I have a few thoughts in mind for your consideration. First, the first has to do with the assertiveness. The assertiveness of this court, right? So much hay has been made about Chief Justice Roberts' testimony during his confirmation hearings, analogizing Supreme Court justices to baseball umpires, right? And their job is to apply the rules, not to make them, right? They have an important role, but it's a modest one. No one ever went to a ball game to watch an umpire, right? Now, there's many things one could say about that analogy. For example, then why do you refuse to answer questions about constitutional law? Just tell us if it's a ball or a strike. What's the big deal, right? Or why do you want this job? You're an all-star pitcher, right, making a lot of money. You want to, you know, why would you want to switch? Why would you want to give that up to become a mere umpire? Roberts has emphasized humility, restraint, modesty, right, just calling balls and strikes. After he was confirmed in a graduation address at Georgetown, right, he said, if it's not necessary to decide more, it's necessary not to decide more, right? And so he's attracted trouble for himself, right, by portraying himself as this, as the academics call it, minimalist, incrementalist, right? And in fact, in this case, he's moved to write separately an opinion joined by Justice Alito to explain, right, how all of this language is reconcilable with what he's doing here. And in fact, he even invokes the language of his graduation address and says, sometimes it is necessary to decide more, right? It's not just that the court came out the way it did. It's that the court struck down the statute facially, on its face across the board, despite what the court has been saying in voting rights cases, in abortion cases, about how disfavored facial challenges are and how the court should really be striking stuff down as applied in particular cases and not going broadly, right? The court rescheduled argument, which is it's not unprecedented, but it is quite unusual, particularly when there was any of, I don't know if it's 5 or 6 ways the court could have decided the case on narrower grounds, right? And in setting the case for re-argument, asked the litigants to brief whether they should overrule Austin and this part of McConnell. And this is what Justice Stevens says in dissent, harsh, but in my judgment, not right, at least colorable and arguably persuasive. Essentially, Justice Stevens writes, 5 justices were unhappy with the limited nature of the case before us, so they changed the case to give themselves an opportunity to change the law, right, which Roberts robustly disagrees with and has to defend what he's doing. But it is striking, right, when you compare the language of humility and modesty and restraint, right, to the reality of a very aggressive disposition of a case that could have been decided more narrowly. Whatever the Solicitor General is arguing, the court doesn't have to agree, right? The court could have read this statute not even to apply, right, to the movie, right, to the documentary. That was at issue in the case. That's one of several ways it could have gone. And Chief Justice Roberts said, you know, we can't just interpret statutes any way we want, right? A narrowing construction wasn't possible, which, frankly, is a little humorous after what the court did in the voting rights case last term, in which it very creatively interpreted, right, the Voting Rights Act and the reauthorization of 2006 in order to avoid a constitutional question, right? And Roberts has to try to distinguish that. This court has ways of distinguishing, right, statutory language and of narrowing statutes when they want to, right? The idea that there's nothing they could have done here except grant re-argument, right, overrule 2 cases and strike down the statute facially is just, it seems to me difficult to credit. So that's one thought about the assertiveness, the confidence of this court. A second thought has to do with views about liberals and conservative jurists, right? So the conventional wisdom used to be, and you still hear this in political rhetoric, is that liberal judges have a very broad view of judicial power, right? They are activists. They strike a lot of stuff down in the name of the Constitution. Conservatives preach restraint, a limited judicial role, right, letting democracy do its thing without a lot of intervention from the courts. I just don't see how after Citizens United, after Heller with the Second Amendment, right, after the invalidations in affirmative action cases and cases involving race-conscious student assignment plans and property rights cases and eminent domain, right, the list is getting impressive of ways in which conservative justices want to strike stuff down in the name of the Constitution. Now, there is still plenty that liberals want to strike down, right? When you start talking about abortion regulations or the Establishment Clause, right, or the death penalty in various settings, right? One could go on. Other kinds of First Amendment cases. But it does seem to me that it is not the case, right, that one side tends to favor robust judicial power and the other side tends not to, right? The question for each side is which rights and why, right? And they should be defending their visions, their substantive constitutional commitments on their own grounds and not in deceptive procedural dress, language of rhetoric and restraint. And the third thought I'll offer, and then we'll open it up, is this is one of many areas of law. If you think about race, abortion, gun rights, gay rights, right, commercial speech, the death penalty, the Establishment Clause, the domestic enforceability of international law, one could go on, in which this court is splitting 5-4 or 4-1-4. Right? Chief Justice Roberts is occupying the role that Chief Justice Rehnquist did, right? Justice Sotomayor is occupying the role that Justice Souter did, right? Justice Alito, right, replaces Justice O'Connor, right, which makes a significant difference in terms of ideological reliability, and then you have Justice Kennedy in the middle going one way or the other. And the court's fracturing 5-4 or 4-1-4 almost with perfect predictability in these and some other areas of the law. Not all the time, but in these areas that people care about intensely and arguably care about most. Interesting in this regard that Justice Kennedy is President Reagan's third choice, right? His first choice is Robert Bork, right? You would have seen a lot more reliability if President Reagan had gotten his first choice, like he did with elevating Chief Justice Rehnquist and Justice Scalia. And I think what you see in this case and in other areas of law are competing constitutional visions, right? Competing basic understandings of the basic meaning and purpose of the Constitution. Right, the kinds of rights that ought to be protected in the American constitutional order, the kinds of ways government power should or should not be exercised. Right? Professor Nichol, you invoked Dr. King, right, in racial integration. It's not a coincidence that Justice Thurgood Marshall writes Austin, right? And in the language of substantive equality, when he talks about the distorting, let me restate the language, the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form and that have little or no correlation to the public support for the corporation's political ideas, right? A commitment to evening the playing field, the substantive equality, that if you let people talk so much because they have so much money, other people aren't going to get to be able to talk much at all, right? That is much more of a progressive constitutional vision, right, resonates with other progressive commitments in other areas of law, like in terms of equal protection. And is it substantive equality or is it formal equality, right? The other side doesn't have this view. In fact, Chief Justice Roberts says, this is what's really going on. I got you. See what all these law review articles are about. It's about substantive equality, and therefore it's out of bounds, right? Much more of a formal equality. Let everyone speak, keep the government out. Very different views about the role of the government, right? For the liberals on this court, government is part of the solution, right? For the conservatives, government is a part of the problem, right? And the First Amendment keeps the government at bay, right? Very different constitutional visions you see in this case. So let me stop there and open it up to you folks for your questions about anything any of us have said.
Neil, can I just add
Absolutely.
one point,
Absolutely.
principally for the first-year students, and that is that I think you might see this a little later, not having had the First Amendment, but in some sense I would just make the point that Mike and I, at least, are like, in this discussion, two ships passing in the night. I also think there are an array of difficulties with the way the McCain-Feingold Act was written, with the application of it by the FEC leading up to some of these disputes. What I find unacceptable and horrifying is the move from that, which could have been, as Neil said, handled in any of 25 different ways, to the extraordinary conclusion that corporations have the right to tap their treasuries to spend unlimited amounts of money in electoral campaigns. And on this point, it's not simply, or not even, for me, principally, the distinction between corporations and people. There are all kinds of different corporations. There are nonprofit corporations. There are for-profit corporations. What is the large move here is to say something which was rejected very profoundly in the past, that is that corporations have a constitutional right to tap their treasuries, which are immense frequently, and which arise from their power in the market, and to use those treasuries to have impact on the political process. For 100 years, we have said that's unacceptable. It means that when now a corporate lobbyist, when Blue Cross Blue Shield or whoever goes and says, I'm prepared to spend this amount of money to take you out, that there are many multiples of dollars behind that threat compared to the already lousy system that we have in place. So I just, for clarity, we end up largely talking about two different things. And it's the second one that I find so difficult to square with constitutional equality. Sorry.
Great. Yes.
Can Congress craft campaign finance reform legislation that would not offend the Constitution under the interpretation in Citizens United? And if so, what would that legislation look like?
Well, for me, Citizens United, so long as it stands, makes any limitations on contributions, expenditures, or the like silly. I mean, what sense does it make to say that you can't give more than $2,000 to an electoral campaign, but that Goldman Sachs can do, in effect, the same thing by spending billions of dollars? It makes it comical. And I say that as one who's worked on campaign finance issues for...
So he knows comical.
For decades, that's right. I know comical and I know troubled, and I know distinctions which are immensely difficult to maintain, largely because of the position the United States Supreme Court has taken. Now, I think for activists, they would say you can have steps which are designed to limit corporations' ability to make these sorts of expenditures. Things like this, the CEO of the corporation has to get up first and say, hi, I'm from Blue Cross Blue Shield and I'm paying for this ad to take out Richard Burr or Kay Hagan. There are arguments that you could say you would require shareholder votes in order to make these kinds of expenditures, maybe supermajorities in that. We don't know if any of those are constitutional, but those would be steps to try and get directly at this notion. More broadly, I know in North Carolina people are going to say, and in the Congress they're going to say, all that makes sense now is to have public financing. But public financing has to be voluntary in our system, and so I think folks think the ideal, given Citizens United, would be we have a voluntary public financing scheme. Candidates can sign on to it and implement it, use it. Maybe 40% or so of candidates will do that. So we'll have the publicly financed candidates, and then we'll have the corporate logos on the other 60%, because that you can't stop the expenditures unless we amend the Constitution, which are reflected in Citizens United.
As it's written, the decision does leave in place, at least de jure, the restrictions on direct contributions from corporate treasuries. And so most of the regulation is left in place. All that's eliminated was restrictions on the capacity of groups to speak. And the fact is, 23 states right now allow direct contributions from corporate treasuries, which this actually left in place. One of those is the state of California. It's not dominated by corporations. It's dominated by nut jobs, but it's not dominated by corporations. So a level of restriction that goes way beyond this is already in place in 23 states, and we're not seeing disaster.
I think it's a good question. I think the Schumer legislation that's being proposed in Congress tries to limit foreign corporations and their ability to use general treasury funds, tries to prevent government contractors from spending money on elections, right? Those corporations who receive TARP money, enhancing disclosure requirements, right, and disclaimer requirements, requiring shareholder notification, right? And there's a lot of talk about bolstering shareholders and protecting shareholders, although frankly, if it's good for business, I'm not sure shareholders are going to tend to mind, right, that corporations are spending money on electioneering communications. But there are lots of proposals, right, circulating, and certainly the contribution limits are still in place. And as I think Professor Nichol is saying, is who cares whether they're in place if corporations can just do this, right? It's not hard to know which corporations are for you or against you if you're a candidate, right, for office. So this is going to go on. There's going to be a legislative response given the degree of public disapproval of the decision. But what is going to be upheld eventually, right? The story continues to be written. Okay. Yes.
Professor Nichols, you talked about this a little bit. How there's the extra problem of having so many international companies that have subsidiaries in the United States and opening the ranks for those subsidiaries to really exert some power in our election process. I wonder if you could both talk a little bit about what you think the sort of real repercussions that we can expect to come from that are, and also, do you see this as an area that Congress will potentially limit in the future, or that the court could limit, given this opinion?
Well, I was trying to say, I think that's an example of the complications that lie out there that are going to have to be addressed one way or another. I'm not sure the extent to which the court was thinking about this question, but as your suggestion indicates, there are American subsidiaries of not only foreign corporations, but foreign government corporations, which have massive resources. Now, I'm guessing, I have little doubt that Congress is going to act on that front. We're not going to, the Congress is not going to sit back and say, okay, that we have to give over 30% of the airtime to Saudi Arabia in our electoral contest. The statements the court has made that you can't distinguish amongst corporate speakers, amongst speakers by identity, would tend to suggest that might be constitutionally troubling, but I can't imagine it will actually be troubling. Even this Supreme Court is not going to say you can't do anything to limit the ability of China to dominate our elections. But see, I think you need to go beyond that. Okay, you'd say, well, what about foreign stockholders in American corporations, which are massive, I mean, huge numbers of them. Are we eventually going to say, this is a rule I'd like, okay, you can't, a corporation can't engage in electioneering from its treasury if it has any foreign shareholders. That'd be good, but I think it shows how difficult the problem is. I have no doubt that will come up. I think like the permission or the procedural notions, it'll likely result in action by the Congress, which will then result in action again by the Supreme Court. And I think there's a little bit of a sense that, well, we've cleared the decks here. I mean, corporations can do anything they want, so we don't have any difficult analytical problems anymore, and I just think that's not going to be true.
Yes, Gus.
Two maybe sort of unrelated questions. First of all, I can assure you that some of us try to think in architectural terms about these issues. And in doing so...
And the rest of you are building code.
In doing so, that's right. In doing so, I have a couple of thoughts. First of all, do you think maybe an opening has been laid here for the principle that money is speech and that individual donations, caps upon individual donations to politicians might be attacked next? And secondly, do you not think there might be a kind of demeaning quality in the criticism of this opinion about the electorate itself, i.e. that the electorate is so easily manipulated by ads and by money in the process? It's something that's commonly thrown around in the public square, and yet we don't have a President Ross Perot or a President Steve Forbes or a President Mitt Romney, all of whom had a lot more money than their opponents. So, two questions.
I do think, right, the majority of this court, right, tends to believe money is speech, right, and I think the minority tends to believe no, money is money, speech is speech, right, and there are meaningful differences. They haven't given indications yet that they're going to follow that logic all the way out, right, and start striking down contribution bans. I can see how certain justices could use sort of stare decisis logic to say that was the Buckley compromise between contributions and expenditures and we'll abide it. Though, of course, right now you've got stare decisis not carrying the day in this situation. And I don't know what will happen. I tend to be of the view, right, that if you allow unlimited expenditures, right, that these sort of limits on contributions are sort of a sideshow. In terms of the amount of money that's going to be at stake, right, and the amount of influence of money on elections. But I don't. Certainly a majority hasn't yet said money is speech and that's the end of the matter, right? They haven't come close to doing that. But how much of a difference it would make if they did, right? If you get rid of the contribution limits, not at all. Not so clear to me. On the other hand, other people will say we'd still rather have the contribution limits than nothing, right? And that may be correct. I just don't know enough about the problem. In terms of the American electorate, it's certainly not a. I would agree that it's not a favorable characterization, right? Whether or not it's accurate, I think, is a different question. I'd rather be, right, the side that is spending lots and lots of money for my cause, right, than the side that isn't. I would like my chances, right? You speak the most, people have limited time, right? They keep hearing certain things, certain associations with certain sides and disputes, right? I'd like my chances if I'm vastly outspending my adversary, and that seems to be, right, the way American participants in American politics view the situation as well.
I end up, as long as this decision's in place, I don't think it's very important whether we have contribution limits or not. Perhaps there will be a broader move to attack contribution limits. But, I mean, if I were in the legislature, I would repeal them myself because they don't make any sense given this ruling. I think you raise an interesting point, and this is part of the challenge, in my judgment, that your generation is going to have looking at this issue. It's true you can characterize this as an unappealing vision of the American electorate, or maybe the more pragmatic way of looking at this is you can look at this through the very narrow lens that the United States Supreme Court always has. Is this corruption? Is it quid pro quo purchase of votes or not? I mean, and to me, that's not what's going on. That's not the great dilemma. That's not what is horrifying about this decision. What's horrifying about this decision is it is now constitutionally laudable for one with massive resources, who has a great deal at stake in the legislative process, to go to legislators and say, if you don't come my way, I'm going to spend $5 million to take you out. Now, if we think that doesn't have an impact on the deliberation of those legislators, then I would say we are massively fooling ourselves. And under the present regime of the United States Supreme Court, that notion, which is what I think of as we want people to be able to speak as freely as humanly possible. That's the essence of this system. What we don't want is people to be able to game the system and throw their weight around because they have huge resources that others don't. We haven't been able to figure that out. God, I hope you do, because I hope we don't lose this democracy. But it's something different than corruption or the appearance of corruption. It is throwing your weight around in a way that trumps the democratic process. And it seems to me that's a very powerful question.
Well, we are out of time. I want to thank Professor Nichol and Professor Munger for joining us, and thank you folks as well for being here today.